Okay, good evening, everyone, and welcome to the Ross Parsons Centre for Commercial, Corporate and Taxation Law and Downtown Business webinar series. We've been running these webinars for the last couple of years since the pandemic first started. And one of the fantastic features of these webinars is that we're able to get some amazing speakers from all around the world to share with us some of the research that they've been doing and to share developments in law reform in other jurisdictions. The topic for tonight is discussing recent insolvency reforms in the European Union, with a particular focus on how those reforms have been implemented in Italy. I'm delighted to introduce our presenter for tonight, which is Dr. Irene Polastro, who is a researcher in the Department of Economics, Social Studies, Applied Mathematics and Statistics at the University of Turin, and she's currently a visitor in the Ross Parsons Centre here at Sydney Law School. Dr. Polastro is currently researching on a project about crisis prevention systems and organisational obligations for entrepreneurs in Italy, and she's going to talk a little bit about that topic tonight. She teaches courses in commercial law, corporate and insolvency law, and financial markets law at the University of Turin, and she has a PhD in commercial law from Bocconi University, having previously worked in commercial legal practice in Italy. So thanks very much, Irene, for giving up your time tonight to share with us some of the interesting research you've been doing on insolvency reforms in the European Union. Just as a matter of housekeeping for those who are on the line, if you do have any questions during the presentation, if you can use the Q&A button, which you should find on your Zoom toolbar. This session is also being recorded, and we will send a copy of the recording to all of the registered attendees, and we'll also be posting that up on the Sydney Law School YouTube page. So without further ado, I'll hand it over to you, Irene.
Okay, so thank you, Jason. And before I start, I just wanted to quickly thank all of you for your participation, and Professor Harris in particular for giving me this opportunity, host me at the Parsons Center, and also for his insightful advices and discussion of these days. So my topic for tonight is, in fact, insolvency and restructuring reform in Europe. And in particular, I'm, of course, focusing on the Italian experience in this context. Starting from the European framework, in the context of the CMU, that is the Capital Markets Union Action Plan, the European legislator in 2019 approved this directive that you can see on preventive restructuring frameworks. And basically the aim was to try to give some common principle for the regulation of insolvency in the internal market. And as you might know, the directive, maybe instead of the other main source of law, that is the regulation that is directly applicable in all the member states, is precisely normally used to give only some common goals. So the idea is that the member state should reach a minimum level of harmonization, and then the single member state are left a bit more free to choose how to reach these goals, so through their own national laws of implementation. So in this context, the objectives are the one that you can see listed here. So basically, all member states, according to the European legislation, should have a system that first gives viable companies that find themselves in financial difficulties access to a whole system that allows them to restructure their debts. Second, give also sole entrepreneurs, meaning natural person as well, a second chance by waiving the debt in full. And finally, rules to make insolvency proceeding more efficient, and in particular, the aim should be to shorten their duration. Then if we look a bit more in depth in this rule that you can find on the European Union website, we realize that materially the options that are given to the member states are really broad, meaning they are left great flexibility in the process of implementation so that of course, it's not likely, but it wasn't even the aim, to result in a strong harmonization. So let's move to the Italian experience. So with respect to what happened in Italy, actually, we had originally an old legislation that dates back to 1942 that was called Bankruptcy Act. And in 2017, we started a legislative process. So basically, it started before the introduction of the 2019 directive. And actually, because of this, it was also pursuing like objectives that were only partially similar or congruent with the one of the European legislator. And for this reason, as you can infer from the various interventions of the legislator that you can see here listed in the slide, the entry into force of this new law that is called Crisis and Insolvency Code, that was initially planned for August 2020, was delayed, and then the text was modified on the one hand, actually to give a prompt answer to the pandemics that in the meantime exploded, but also on the one hand was really intertwined with the directive transposition. So the result of this bit fragmented part is a quite complex test that is now offering debtors quite a wide array of instruments. So starting to look to the underlying principles and the main innovation in the Italian legislation, first ones are related to efficiency, simplification, and the goal of shorten the duration of the procedure. Which are the tools in this context? First, we introduced or reinforced already existing out-of-court procedures. So based on the idea that, of course, the less you require a court intervention, the quicker will be the procedure. Second, we managed to have at least partially a sole judicial procedure in the terms that whichever instrument you choose, you have basically the same rule for the access, same rules on the main documentation that you should give either the professional that is assisting you or the court, more or less same rules for protective measures, so that eventually, if you have at some point to move from one instrument to another, then you can do it quite smoothly. And third, we have, and this is again quite an innovation, specific rule for companies, so different from let's say partnerships or other type of enterprises. And for group of enterprises, basically the idea is that you can file a sole group procedure where doing so is more convenient than file multiple, let's say, separate petitions for all the companies of the group. Second and main aim, I would say, early warning and recovery. So what are the strategies that we have chosen to implement and to reach this goal? First, we have now a different definition for crisis and insolvency, whereby crisis is the status of the debtor that makes insolvency likely, and it is manifested by the fact that the provisional cash flow, the prospective cash flow, will be insufficient to meet the obligation in the next 12 months. While insolvency, as the common and widespread definition, is basically the status of the debtor that is already no longer able to pay all his debts when they fall due. Second, we strongly rely now on these organizational measures that Jason was mentioning. And it means that the enterprises now, according to the civil code, need to establish adequate organizational, administrative, and accounting structures that should be capable of promptly detecting the onset of a crisis. So this is now a specific obligation incumbent on the managers and its source of autonomous liability. And of course, these measures, the law says this as well, should be proportional, meaning both proportional to the size and the type of the activity, because obviously the organization needed for large firm is way different from family partnership or for non-profit organization. So the idea is also we don't want to turn what should result in a beneficial outcome in some more burdensome obligations. In this context, we also introduced a so-called early warning system. So basically, even if the management is either unresponsive or maybe unaware of the signal of crisis, then we have the supervisory body of the debtor company that must promptly notify the managers if it believes that some situation of crisis is arriving. And also, the notice must contain a specific deadline, not exceeding 30 days, within which the management body must also report to the supervisory body which are the initiative is taking to solve the situation. Apart from this, that is called internal warning system, we also do have a system, similar system for the so-called qualified public creditors. So basically, an example might be the tax collection agency that have this similar obligation to notify the debtor where they detect some signal of crisis. So this idea, all these ideas already had been the basis for some previous but really specific intervention and modification in the old Bankruptcy Act. But this new law now really wants to give the idea of a complete change and paradigm. So when I write from creditors to enterprise, it's because if the old bankruptcy law was basically built with the main, and I would say only intention to maximize creditor satisfaction, the value that this new law seeks to protect is instead more the one of preserving the debtor activity, while of course you have to make sure that the creditors can reach the maximum satisfaction. But let's say that the first and primary objective needs to be restructuring, of course, where possible, and have liquidation as the last resort. Because it is obviously considered the most favorable outcome for all the creditors and, let's say, stakeholders involved in the life of the firm. And indeed, this is reflected also in a new obligation that is in the initial part of the law. That is an obligation for all the parties involved in the transaction and in the restructuring proceeding to act reasonably and in good faith. This obligation particularly lies on creditors that are expressly requested to be cooperative and give a tangible contribution to help overcome the distress of the debtor. And from punishment to recovery, just to say that even if it might seem a purely formal intervention, we also adopted the change in terminology, because in Italian, the old name of bankruptcy was fallimento, that means failure, while the reform has changed the name into judicial liquidation, liquidazione giudiziale, so clearly aiming to give this new procedure like a more neutral qualification, so try to avoid that stigmatization that might come from the entry in one of these procedures. So this is finally also reflect, as we will see in a moment, in a visible preference of the legislator for private negotiated solution for the crisis and the insolvency, which is in turn consistent in the end with the view of crisis no more as a stigma, but as an almost physiological moment during the life of a business. I mean, it might happen, and it's not necessarily the result of an unskilled or fraudulent management. And so the other way around, the public court intervention is now only needed and relegated when it comes to protect external third parties' interests. Finally, a brief overview on my postscriptum in the lower part of the slide. So directors in this context are strongly empowered, in the sense that not only they have the exclusive power to choose the instrument, to start the process, the procedure for restructuring, to propose the plan and all the content of the plan, that of course it makes sense since in turn they are the one who have the sense of what is going on. But in the plan, they can also now include amendments to the Article of Association, so to the Constitution. That means that they can modify the corporate structure. So with merger, all of the extraordinary transaction you might think of. And also they can modify shareholder rights. And if every of this decision can be taken without the consensus of the shareholder, while, of course, as you know, in ordinary circumstances, we need like a supermajority voting from the shareholder meeting. And shareholders, on the one hand, also lose the power to remove the director, except if they have a justification, but this justification should be different from procedure-related issues, and in any case, should be or is subject to court approval. So basically this new, let's say, distribution of power is interesting, I think, not only because it leads to what seems to be an actual sterilization of shareholder right in this context, but also because it represents perfectly an example of how broad and flexible is the European Union directive, because actually this is an application of the principle according to which member states were only asked to have mechanisms to avoid the possibility for shareholder to unreasonably block any restructuring process. So this is the maybe beyond of what requested option that the Italian legislator adopted. So that said, we can move to the
sorry, Irene, can I just ask a couple of questions?
Yeah, of course.
So we've got one question from an audience member, David, who asks, how is the obligation to act in good faith enforced on the stakeholders?
I mean, right now we don't have so many cases,
right?
Stakeholders, because of course into court, but I mean, as I was telling you, the reform in the end just entered into force, let's say 1.5 years ago, just in July 2022. So we don't have real grounds to,
sure.
I mean, materially answer this question.
Yeah. Who is able to
just an
sue
obligation to be collaborative in the transaction.
So if we had a circumstance where maybe a creditor, maybe a supplier or a landlord or something was acting unreasonably, could a creditor sue them in court for this obligation, or only the
Also
debtor?
the debtor, I would say. So
right.
You should be considered liable because somehow you try to stop the possibility for the company to be restructured and so for recovery.
Okay. I also then was going to ask, just as you were speaking about this obligation on the debtor company and its management to really be, monitoring what's happening in their company and to become aware of the signs of crisis. What's your sense of how successfully that is being implemented in Italy, and particularly with small and medium enterprises? And that the context for this question is, here in Australia, we're having an ongoing debate about why many small businesses end up in a very bad insolvent state. And some people have suggested, including some insolvency practitioners, that perhaps the level of management capability of some of those small entrepreneurs is not as high as it should be. And so maybe they are good at producing their goods and services, but not so good at doing the management of their business. And so when I hear these reforms in Italy, I think that's very interesting and would like to see something like that in Australia. But I do wonder how, what kind of education system we have for entrepreneurs in Italy, what sort of support systems, these types of things.
Yeah. Of course, again, first, the obligation was originally taught basically for joint stock corporation, and it's like 20 years that we have it, maybe more. With respect to small businesses and sole entrepreneur, it was only introduced in 2019. So when the law actually popped out, but then, as you know, the other parts of the law were implemented late in a later moment, but this one was introduced immediately. So we have a bit more, action going on this. And I should say that, again, maybe it's too early to tell, but we have a lot of bodies like Association of Auditors, external advisors, etc., that are publishing a lot of guidelines on how you should draft this measure, or how which are the most adequate measures if you are small, if you are doing this type of activity, or which are the indexes you should pay a bit more attention on. So basically, it's kind of soft law help. So it's not that directly comes from the legislator, but still a lot of bodies and associations are now really active in helping the entrepreneurs, and also giving like seminars, general from help and aid to the enterprises, also small ones, to be able to actually detect the signal of crisis.
Oh, that's fantastic. If the different professional bodies and like chambers of commerce and these types of bodies are supporting these new measures and trying to support small businesses, that's fantastic. Yeah. Great. Thank you.
So as I was telling you, now maybe we can move to what are the instruments that we included in our new crisis and insolvency code. So the first thing you can easily see if you look at the slide is that we have now more tools, actually, in number than in the old law, that I think in brackets can call into question whether the goal of simplify the system was eventually reached or not. You see the instruments in the new law in an order that tries at least to reflect the degree of their impact on third parties on the one end, and thus of court involvement. So the idea is basically that the more the instrument is able to affect the interest of creditors, shareholders, stakeholders, etc., the more the level of the court involvement increases. In any case, one thing worth noting is that regardless of the instrument you choose, a procedure can only be initiated by the debtor himself. And by the way, this is another really good example of the flexibility given by the European Union, because under the directive, member states were left free also to have creditors or employees representative to start, so to enter restructuring proceeding. But the Italian system only gives this possibility to the debtor himself, while, of course, when it comes to irreversible insolvency and liquidation, then the initiation right is, of course, given also back also to creditors, and in some circumstances also to the public prosecutor. So, of course, we won't have the time to cover and go in detail through all the instruments offered by the legislator that, in any case, as you can see, coherently with, let's say, the new guiding principles are for the great majority restructuring proceeding, so non-liquidation instrument. But I would like today to draw your attention on the first one, that is the negotiated settlement, that we called composizione negoziata della crisi, because this is first nothing that resembles the old solutions that were already adopted in the old bankruptcy law, and in turn is the real innovation, I would say, of the code. And actually, it was neither originally included in the project of reform, so it wasn't even in the plan of the legislator, but it first saw the light in 2021 more as an emergency response to pandemics, so to help the businesses basically. But then it was considered in the end to be maybe of some general use, and then it was included with some small modification in the final text of the new crisis and insolvency code. So what is this negotiated settlement? we can classify this instrument as the most informal one, voluntary out-of-court restructuring procedure, non-certified. What are the general characteristics? So first, one of the most interesting, I think, regarding the subject, this can be requested by any type of entrepreneur that is facing a financial or economic crisis. So regardless of the type of activity, can be agricultural or commercial activity, and of the dimension. So basically, it is believed to be, let's say, an initial step into restructuring that it's suitable to solve a wide variety of situations. So from the small business to the larger. Of course, and this is the only requisite, in turn, the entity should be somehow recoverable. Okay, so basically, it is in a situation that potentially could lead to insolvency, but it's not already there. So you can try to enter this procedure. So the paramount goal basically is the one of preserving the ongoing business of out-of-court procedure, so no judicial authorities involved. The rapidity and cost-saving goals that are at a really initial principle of our legislation are granted by the fact that this is also a fully online procedure. So this procedure also is intended to give instrument to less organized businesses, so small businesses in the end, and to avoid the need for them maybe to hire insolvency lawyer that can assist them in drafting the plan, etc., that in turn would, of course, increase the cost. In this online platform, you can also find first a checklist. So basically something that tells you which are the documents you have to file, which is the content of the plan you should draft, and also a kind of practical test that helps the enterprise to state if there are concrete prospectuses for recovery. So basically, either the sole entrepreneur or the management of the company can start the procedure by filing the online application to the competent Chamber of Commerce portal. And the Chamber of Commerce, upon receiving this request, will appoint an independent expert. This independent expert is just someone that should facilitate and support the negotiation between the distressed company and the creditors to help them to find a viable solution, basically. So it's not it's just independent, but not either for the debtor or for the creditor, just to mediate, basically. Everyone is invited to make proposals, so all the stakeholders involved can make proposals, and the maximum duration of the negotiation is 180 days. Also, not being like a proper insolvency proceeding, none of the traditional effects of insolvency proceeding is actually realized. So no stay on creditors' individual actions, no ban on the possibility for the entrepreneur to go on with the payments, with regular payments, and it totally remains in charge of the management of the activity, both for ordinary and extraordinary actions. And this is also proved by the fact that also for non-ordinary payments that might be considered to be somehow detrimental for the possibility to actually have a successful recovery, the professional, being independent, has in turn a notification obligation. So maybe you shouldn't go on with this payment because maybe it's not appropriate, but and it could also, let's say, include in the online procedure a written dissenting opinion, basically to avoid liability. But he doesn't have any possibility to prohibit the entrepreneur to go on. So basically, he's not a supervisor. Finally, the negotiations are totally private and confidential. So confidentiality should be granted during all the course of the procedure to avoid the stigma that could arise from the fact that actually the firm is entering such a type of procedure. So no court involvement, neither directly, not through a kind of supervisory commissioner, apart from a case that is the case in which the enterprise wants actually to apply for the so-called protective measure. So basically to obtain the stay of the creditors on individual actions. Also, in this case, we managed to find a different solution from the ordinary ones. So to speed up the times a bit, actually, the court just need to, let's say, give a confirmation of the stay of the protective measure. That means that basically the entrepreneur registers the request for the application for of these measures in the electronic register. And from that moment on, the measures are effective. So there is immediately the stay on creditors' individual actions, and then he can file the application to the court, and the court only needs either to confirm or remove the measure if find them inappropriate, useless, detrimental, etc. But the protection comes immediately. What can be the final outcome of this procedure? So if the procedure is successful, it can result either in a totally private contract that you can also conclude with just one creditor, maybe two, maybe more. There is no minimum threshold of participation, or end in one of the first two crisis and insolvency recovery tools, so either the certified restructuring plan or the moratorium agreement. So basically here you see the plan need to be certified by a professional. You don't need to appoint a new professional. You can use the let's say the external professional already appointed by the Chamber of Commerce. And basically the certification only states that the business data and indicators on which the plan is based are accurate and reliable, and that the plan is it's feasible. If debtors and creditors do not reach any type of agreement, the debtor, of course, can move back to ordinary instruments and procedure that you can see listed here, including, and you cannot see it in the list because it is just an outcome that you can reach if you previously entered a negotiated settlement, a simplified composition with creditor, so simplified version of this last composition with creditors, that basically can be adopted when you realize that no concrete restructuring possibilities are there. With some simplified rules, it means you don't require any class voting, so no creditor vote, and just let's say the only rule should be that what you reach through this simplified composition is no worse off for the creditors that in a proper like liquidation procedure, and all the remaining value, so the remaining assets should be distributed according to the absolute priority rule. So basically, if you have one creditor that has priority over another, the creditor need to be paid in full before the other is entitled to receive anything. Regarding the others, let's say crisis and insolvency recovery tools, as you can see, there are many. They have something in common. So meaning that there is at least the certification of an independent professional that might instead be lacking in the negotiated settlement. Again, the initiative in this case lies solely with the debtor. Non-participating creditors need to be paid in full, but if you want to bind also dissenting creditors, you have the option to do this. You move to the last, measures. But in this case, if you want to bind dissenting creditors, either you have to reach some threshold of participation and approval, and in any case, you need also a court involvement. So at least an ex post approval of the plan. Moreover, let's say that to give an incentive to try to enter a restructuring proceeding and not going directly to liquidation, There is the advantage that any action, payment, guarantee that is made in execution of one of these agreements is not subject to clawback actions in case then you have to enter into liquidation. And also in all the debtor in possession procedure, when you receive external finance that can help you, okay, in drafting the plan and find a solution with your creditor, this external financing is ranked as a super secured debt, and this classification is maintained also in case of liquidation. So if you then have to turn to a liquidation procedure, of course, except for fraudulent behavior. So basically, you realize that the restructuring plan was based on false information and data, and the lenders were aware of these circumstances. Finally, and generally speaking, also in this case, the stay on creditor is not automatic. So you have to apply for protective measures. They can last only 12 months. It means that basically, if you know that you have no possibility to successfully recover, you might want to directly enter into liquidation. Otherwise, you have only 12 months period of time in which the stay applied.
Sorry, Irene, can I just ask a question on that? So
yeah.
with the stay and you have to apply to the court, is that for each of these different procedures?
Yeah, of course.
Okay. So there's no automatic stay with any of these. Okay, right.
Okay, but we will see later that we have specific instruments for minor enterprises. So the small ones. In that case, we have also a minor option for the composition with creditors. For instance, one of the, let's say, less burdensome measures that are granted to minor enterprises is that the stay is automatic in that case. But I mean, it's only exceptional. In this case, for instance, for reason of make the life more simple for small businesses. But here, let's say, generally speaking, you have to ask for a stay. It's not automatic. Okay, so as you can see, then we have a lot of crisis and insolvency recovery tools, and then we have the classical judicial liquidation if you are already insolvent with no possibility to, to recover. Quick remarks, as I was telling you, we also have some instruments for small businesses. So actually, in this case, we have quite a different notion of over-indebtedness. That basically is just formally a different notion, because the over-indebtedness is nothing else than the state of crisis or insolvency of subject that cannot be subject to judicial liquidation. So consumers, professionals, minor entrepreneurs, agricultural entrepreneurs, innovative startups. So these are believed not to be suitable to be subject to judicial liquidation, so they have alternative instruments. Why we have actually this different naming? First, just because it's commonly used in the European framework, and second, because of some different possible criminal fallouts. So I've written in the title SMEs, but actually, while small and medium enterprises are normally, so in Europe at least, defined by number of employees and annual turnover, and we have also a differentiation in the European general framework between micro, small, and medium enterprises, the last and biggest having fewer than 250 employees, and an annual turnover not exceeding 50 million euros. In this case, we have a specific definition that actually recalls the one of our old bankruptcy code. And so the enterprise is in turn defined not as small enterprise, so to avoid, or at least try to avoid confusion with the notion of SMEs, but it's a minor entrepreneur. So the definition is that the minor enterprise is the one that jointly meets the three following requirements. So the one I listed in the slide. that are related to total amount of assets per year in the last 3 years, same for annual revenues in the last 3 years, and total amount of debts in that year, including those not past due. So these are the measures that qualify the minor enterprise. So the minor enterprise has specific instruments, specific tools. One is only dedicated to consumers. One is the minor composition with creditors that basically recalls the, let's say, ordinary composition, so the one that ordinary business can use, so not minor ones. It is a minor version, basically, that is a bit less burdensome, as I was telling you, but it's still more complicated than the simplified one that I mentioned before as an outcome of the negotiated settlement, because it's different. We have the simplified one, simplified composition and minor composition. So again, you might ask how the goal of simplification happened. Maybe it didn't that much. Let's say it still have some more degree of complexity with respect to the simplified one. It can be both in continuity and with asset liquidation purposes, while the simplified one can only be in case of liquidation, in case you need liquidation. The activity can be continued either directly by the same debtor or indirectly by another party. You have less rule with respect to creditor votes, but still you need the intervention of the court, both at the initial stage. So they need to tell you, okay, you can enter the procedure, you can start the procedure, and at the end, when they need to approve the plan that has been voted by creditors. So slightly easier rule, but still a bit complicated, and court approval is necessary. The attention to these small businesses in turn gives me like the cue to move to my next and also, let's say, final consideration that are mostly related to what Jason was actually asking at the beginning. So is it actually functioning? How is the insolvency system going? Of course, so the question in the title, is it working, is again quite paradoxical, because I told you it's like 1 hour and a half maybe that the reform is now entered into force, so less than 2 years ago. So maybe for a proper and complete evaluation, we need more time. But at least if we look at the data, we might try to find some first conclusion. So if we look at what happened under the old Bankruptcy Act, we realized, and as I mentioned, this law was basically not really focused on restructuring. We had some instruments, but let's say that the law was almost solely dedicated to protect creditor interest. And so in this context, liquidation was by far the most used procedure. So 9 out of 10 procedure were liquidation. And in terms of numbers, as you can see in the brackets, we have liquidation ranging from approximately 7,000 in the period 2007-2009 to more than 12,000 in the year following the financial crisis. While the other procedures, so composition with creditors and restructuring agreements, were only the 10%, and basically they were mostly used by larger firms because of their cost, complexity, etc. While if we move to the new framework, so we observe the numbers of the liquidations right now, we can see that in these last years, the number is significantly below historical levels. And in the first 3 quarters of 2022 in particular, they were 20% less than in 2021 and 35% less than 2019. So before the code and also before the pandemics. I should say that it's maybe a bit silly and idealistic to think that this decrease only depends on the fact that practitioners immediately shift to this new principle of prevent restructuring, to preventive restructuring, prevent liquidation. So the explanation might also be another. That is, we do have in our civil code this ROL rule. So it's recapitalize or liquidate. That basically state that in case of losses that make the net asset at the book value fall below the minimum capital requirement to establish a company, you have the obligation either to inject new capital, recapitalize, or you have to immediately go into liquidation, recapitalize or liquidate. This rule was suspended during the pandemics and has not yet been reintroduced. So, of course, the fact that liquidation are decreasing might also be due to this fact. On the other hand, what is interesting to look at are the numbers of precisely the negotiated settlements I was talking about. So again, the testing period is not that long, but at least it ranges from the end of 2021, when it first entered into force, until the datas are until May 2023. So in this period, we had approximately 800 requests that are increasing in time, so in the semesters, with also an increase in numbers in the measure of 1 out of 3 firms that are not requiring any stay on creditors. So again, increasing. And of course, this might be an encouraging signal in the sense that might mean that the firms feel that the situation is not already so bad or so compromised that they need immediately protective measures, that it's good news because it might mean that they are starting early. And this is basically the intention of the legislator. Nonetheless, we have to notice that the level of success of this procedure is still relatively low, in the sense that only 12% of this settlement ends into a successful agreement, but also the number is increasing. So out of 316 procedure concluded, we have only 39 successful, but 3 in the first month. So it's, let's say, constantly increasing in the semesters. So again, why it might be still that low? Of course, we are starting to gain confidence with this early detection of the signal of crisis, but maybe a real change in mindset and habits require a bit more time, and not only on the side of the firm with all the organizational measures, etc., but also maybe in the person of the professional that is entitled to help the negotiation, because maybe these professionals are still used to old mindsets, so maybe they are not already that effective in finding the best solution to help the parties to reach a final agreement. But a significant detail that is included actually in the law is that these figures need to register in some kind of register, and to be able to register, they should have some specific training. And this training for these figures include a lot of like soft skill and negotiation techniques. So with the aim precisely to help the parties to find a solution. Really a final remark that is related, as I was telling you, to small businesses recovery. The numbers show that this procedure, so the negotiated settlement, is mostly used by really small enterprises. So the 86% of the firms have less than 50 employees, and let's say the 60% only up to 9 employees. So basically, this might be thanks to the fact that it's a quick procedure, it's cheap, and you also have all that online tools that I was mentioning, like the checklist, the practical test, that maybe give the feeling to these small businesses that they don't need to invest, at least at a super initial stage in the insolvency process, to seek for the assistance of a lawyer, so pay for the lawyers and etc., consultant, etc. So invest a lot of money and maybe then go into liquidation. So maybe there are good signals that this can be successful, in particular to help small businesses that in turn, I mean, in Europe, in Italy, are like the 99% of our economic, to actually try to find a first solution for the crisis. So I would say this is pretty much it. I've already maybe talked more than I should. So thank you.
That was great. Thanks so much, Irene. Just a couple of comments and some questions. For audience members, if you do have any questions for Irene, please post them in the Q&A button on your Zoom toolbar, just while we're waiting for those questions to come in. Your comment about the decline in liquidations and the wondering whether that is linked to the continued suspension of the recapitalize or liquidation rule. I would just note that, I mean, here in Australia, but across most of the common law world, over the last several years, we've seen a downward trend in particularly court liquidations. So it does seem like in many countries, Australia, England, New Zealand, Canada, the United States, that the traditional method of, we might say, creditor debt recovery by trying to push corporate debtors into liquidation maybe is starting to change. And I'm sure the pandemic had a lot to do with that, but maybe creditor attitudes are also changing, and just, at least here in Australia, wondering whether it's actually worth spending $15,000 or $20,000 to push a debtor into liquidation, when in almost every liquidation, the unsecured creditors are going to get very low recovery or no recovery. And I've certainly wondered with my co-author, Michael Murray, whether we are seeing a structural change in the creditor population here in Australia, and perhaps in the future we might see, it's just very large institutional creditors like the taxation office and these types of bodies who will actually be pushing for liquidation. The other comment that I would have is, you mentioned that there's a relatively large amount of these companies doing the negotiations that are not seeking stays. And I guess I would just note that, there are some parallels there if you were to look at what happened in the UK when they introduced a stay mechanism for small businesses that wanted to use the company voluntary arrangement procedure. And that was, almost never used. The small businesses were reluctant to seek the use of a stay, but also the financial creditors and the accountants were not that happy to impose a stay. And one of the messages that really shone through your presentation to me, and the lesson that I will take from your discussion as an Australian, is it does seem like that these Italian reforms have been set up with the broader ecosystem, financial and commercial ecosystem in place, so that, you mentioned several times that, there's online platforms, there's sample documents, there's checklists, there's guidance from professional associations. And of course, we do have that here. Our local insolvency practitioner associations, ARITA, AIIP, TMA, they certainly do provide various guidance for their clients and the general public. But it sounds like it's even more in Italy and more detailed and specifically targeted at some debtor management who maybe would not otherwise have that information. So one concern we have here in Australia is whether some of those particularly micro businesses maybe are bypassing the insolvency system entirely because maybe they don't have the assets, or they don't want to pay, or they don't have the knowledge to really track the business's financial performance. So it seems like there's more support in Italy for those types of businesses.
At least, really, this is the idea. And another thing I just wanted to add with respect to protective measures, so stay that maybe also the firms and the debtor is reluctant to ask for, is that in the negotiated settlement, as I mentioned, you have total confidentiality. So basically, external stakeholders that are not participating into the procedure, or let's say the general public, might also not be aware of the fact that you are starting a restructuring procedure. So with respect to this procedure, you don't have any type of obligation to say in the business register, I'm starting this procedure. When this obligation comes, when you file a petition for protective measures, because in that case, of course, you are making something that also can somehow touch the rights of the creditors, of the public, so they should be able to be aware of this. But in turn, if you might want to, let's say, keep confidentiality, at least at the beginning, to see if it's working, then you might think, okay, I'm not starting to request a stay.
So, I mean, here in Australia, we have the safe harbour, which operates for directors to give them protection against potential insolvent trading liability. And we actually had a webinar in this series a few months ago looking at some of those issues. And that's been an issue for particularly some creditor groups here in Australia. They complain that the directors can enter into confidential safe harbour, and really the creditors should be notified. Now, of course, if we did have a formal notification of things like safe harbour, then that could also have a bad effect on the company, because then other creditors would say, oh, I'm going to stop supplying to you, or whatever.
That's the point. So like this, you are trying to start to find a solution with the creditors that, with the help of the independent professional, you might think you can find a real agreement on. And in the end, what is the purpose? To make the other one knows. If you find a solution that make you recovery, so you won't have problem in the future, why to tell the others?
Yep, for sure. Okay, so there doesn't appear to be any questions from the audience, and we're just about at 7 o'clock. So thanks very much, Irene, for giving up your time tonight. It's been an absolute pleasure having you here at the law school over the last few weeks, and
it's
been very interesting learning about Italian insolvency reforms. So on behalf of the audience, thanks very much. And thanks to everyone who's come along tonight for giving up your time. As I said, the session's been recorded, and we will send a copy of that recording to all of the registered attendees. So enjoy. Oh, we've just had one question come in right at the end from Angus. Actually, it's a comment just saying thanks very much. Okay. So thanks, everyone, and enjoy the rest of your evening. Thanks, Irene.
Thank you. Have a good night.